Jerica, it looks like Tristan from our office wanted to join too. She's been, here she is.
Got her.
Got her.
All right. Well, yeah, why don't we go ahead and get started? As people trickle on in, they feel free to. We're also recording. So at the end of the presentation, everybody will get an email with the recording. And then we'll also be sending out a survey as well, and seeing what other ideas we may be able to put on for similar webinars for 2025. So keep an eye out for that email after the webinar is over. Again, that'll be with the recording link too, so you can share with anybody as well. But anyways, let me go ahead and welcome everybody. Thank you for joining us. Again, our webinar this morning is the Payment Playbook, Winning Strategies for Subcontractors. I've got Kate Strauss with Galvanized Law, and I'm Dustin Nichols. I'm with Lakeside Insurance. Before I get into introductions, little rules for the road here. We're going to treat this as more of an open forum, so please utilize the Q&A button at the very top. It's next to chat. Utilize the Q&A as much as possible instead of chat. We'll have that open on our screen so we can stop the present in the middle, answer any questions that you might have instead of doing everything at the end. So if you do have a question, please throw it in there. Either Kate or myself will stop talking and we'll answer any questions that you might have. And then, yeah, I think we'll get it going here. So I appreciate you guys all joining us. Again, this is it's not the best weather outside, but I guess it's a great day for a virtual webinar. So I appreciate you joining us. Again, my name's Dustin Nichols. I'm with Lakeside Insurance. I've been with Lakeside as a commercial risk architect for 10 years now, going on 11 years, primarily focused on the construction industry. My expertise goes back to the workers' comp side of things, so that's why I focus more on the blue-collar construction industries. That seems to be the biggest pain point when I'm talking to my clients, so that's where my focus shifts. My background comes in more of the risk management side of things and less just, selling you an insurance policy. I look at the whole risk, and, kind of what we're diving into today is talking contracts. So I dive into a whole risk. We talk about everything that you should be avoiding risk, reducing certain risks, and then also that transfer of the risk over to an insurance policy. At the end of the day, that strategy basically lowers the cost curve for the insurance portion, at which obviously drives up revenue on your end as well. I'll go ahead and introduce Kate as well. So our other presenter, Kate, she is the founding partner at Galvanized Law. Her cases are focused on issues such as construction defect, mechanics lien foreclosures, delays scheduling, impact claims, and other contract entitlement issues. Kate, I want to thank you for joining me today and doing this alongside me. I'll let you go ahead and take it from here.
Thanks so much, Dustin. And it's nice to have everybody online today. Dustin already mentioned it, but please, if you have questions about what we're talking about, drop it into the Q&A as we're talking, because it's so much more interesting to feel like we're having a conversation than sometimes feeling like I'm just talking to myself. But Galvanized Law Group is a construction law firm. So our clients tend to be large subcontractors, smaller general contractors, architects, and engineers. We provide general representation, so we're due contract review and negotiation, employee handbooks, mechanics liens, sort of like the nuts and bolts legal of your business. And then we do the litigation side of the world as well. So like Dustin mentioned, I defend clients against allegations of construction defect. I prosecute their mechanics lien foreclosure actions. Just kind of soup to nuts, the commercial litigation side of the world of construction law. And a lot of those litigations, my clients will be first time to a litigation. And so sometimes it's not a question of if, it's just a question of when you end up in a litigation. And so really thinking meaningfully about how your company is structured, what your contracts look like, kind of the proactive and prophylactic kind of steps you can be taking to put yourself in the best possible situation for when a litigation arises. It's a little bit about what we're talking about here today. Dustin, I think you're running our slideshow, right?
Yep.
Thank you. So the overall presentation, I want to start at first talking just generally about sort of the law in Colorado and some of the pieces of the statutory law that impact construction professionals. And those are the statutes that I have on the screen in this slide right now. Then for like just so the arc of the presentation is we'll talk a little bit about the law, how that impacts you in a contracting environment. Then we'll move on to specifics of contracts and contract formation law. And then we'll focus at the end on some of like the specific clauses in construction contracts and kind of be talking about, I mean, we called it the subcontractor, the payment playbook. So we're really going to be focusing on how different aspects of the law and the contracts that we're talking about can impact you in terms of either preserving your ability to get paid or not waiving your abilities to get paid. So the 5 statutes that I wanted to talk about, oh, if you'll go back, sorry, just briefly, we'll hit a slide for each of these, but it's the Mechanics Lien Act, the Homeowner Protection Act, Contractor Trust Fund Act, SDARA, which is the Construction Action Defect Action Reform Act, and then the statutes of limitation and repose that are going to apply under SDARA. Okay, now I'm ready. Thanks, Dustin. So a mechanics lien. A mechanics lien is a really powerful tool in order to preserve your right to get paid on a project. Mechanics liens are attaching to the land itself, and that's an important distinction. So, you know, in the court system, we can file a lawsuit and the lawsuit gets filed in the district court. Well, mechanics lien is actually getting filed in the clerk and county recorder's office for the city and county where the land is actually located. So what we're doing is we're attaching the lien interest to the real property itself and saying, hey, we as a contractor or construction professional did something to benefit this land. And now the land has an increased value and we need to be paid for the increased value that we provided to the land. So the lien itself attaches to the title on the land. We have only 4 months to record it from your last substantive date of work on the project. That's really important, the substantive date of work comment, because it can't be just from punch or warranty work. It needs to be the substantive work that is like the work that you contracted to perform or that you were asked to perform. It can be change order work, but it can't be like, oh, I just went out there last week and I added some caulking around the windows, kind of ticky-tacky or punch or warranty kind of work, because that's sort of artificially extending the time for the lien. So if you are looking at the potential that you're going to need to file a lien or record a lien, you want to be tracking it from last date of substantive work, and you need to remember that we have to give 10 days notice prior to recording. So we need to be pushing out notice of the intent to lien, putting it in the mail, certified mail, like preferably by day 12 before we have to be recording that lien at the 4-month mark. The earlier in time you can push out the notice of the intent to lien, the more time you're going to have also just to get the opportunity to negotiate for payment, because the people that you are putting on notice of the lien is going to be the owner of the property, and it's going to be the general contractor if you're a subcontractor on the project. And so sometimes the owner doesn't realize that the general contractor hasn't actually paid the lower tiers. Getting the notice itself is going to be pretty powerful for the owner to be saying, general contractor, get it together, you owe me the obligation under our contract to get this paid. So sometimes the notice of intent to lien alone is a good mechanism for payment, and that's all you need to send out. If you're working with a company like Galvanized Law Group, we can send the demand letter as the cover sheet for the notice of the intent to lien, and sometimes that's useful as well. So the step that happens after the recording, because the recording happens clerk and recorder's office, step that happens after that is going to be that 6-month bullet point at the bottom there. And that's when we file it in a litigation in the county court or the district court where the county is where the property is located. So that's what has to happen within 6 months after last date of services. So what we do is we file the separate lawsuit to foreclose the mechanics lien. And that's to say, have the court say, yes, I agree, you're owed this amount of money, and this amount of money is going to attach to the property itself. Once you foreclose on the lien, then you can ask the sheriff to go forward and sell the property in order to actually recover on the lien. It almost never gets that far. Usually we were able to negotiate a payment well in advance of that. But the other type of actions that we would file, well, the other type of claims we would file in that lawsuit are going to be claims like breach of contract against the general contractor or unjust enrichment against the owner. There's other different types of legal claims that would kind of get bundled into that lawsuit in addition to the mechanics lien foreclosure. So that's the Mechanics Lien Act. And if you go to galvanizedlaw.com, no, galvanized.law, I don't even know our own website. If you go to galvanized.law, which is our website, we do have a client resources section there with a free mechanics lien checklist. If you want to download that checklist, it'll kind of give you the steps to ensuring that you have what you need in order to get the lien filed. All right, so statute of limitations. This statute of limitations relates to the Construction Defect Action Reform Act, and this relates to the time period in which a claim can be brought against you for an allegation of defective construction. And so there's two concepts here. One is the statute of limitations. That's you only have 2 years after you know of the claim to file the claim against the construction professional. And that's going to be when the defect manifests, when they know or should have known that there's an issue. So a really good example is water staining. The first time that you see the leak in the drywall, that is going to be the trigger to say, okay, there's a problem here. That's the manifestation of the defect. And that starts the 2 years from which the claim has to be brought. That's contrasted against a different concept, which is the statute of repose. The statute of repose says no claim can be filed more than 6 years after you complete your work on a construction project. Now, this is going to apply to claims that the owner on the project would be filing directly against you as a subcontractor that worked on the project. If the claim, going back to my stain on the drywall, if the claim arises in the 5th or the 6th year, if it's year 5 after you finish your work and that's when they see the water stain on the drywall, they're going to get those extra 2 years to bring the claim still. So they can extend the statute of repose to a maximum of 8 years if the claim arises in the 5th or the 6th year. But after that, it is supposed to be wholly and completely cut off. That after 8 years after the substantial completion of your work, if the lawsuit hasn't been filed against you yet, it cannot be filed against you. And the reason for the statute of repose is, well, there's a lot of things that happen, right? So we all know that construction happens, in a physical built environment, that there are all different types of factors, weather, maintenance, everything that happens to this construction and this work over time can lead to deterioration of it. It can lead to alternate causes of damage. And also memories fade, project files get destroyed, all different types of things happen that really you lack evidence after a certain point to show what maybe was or wasn't properly done in the first instance or why something wasn't done. So all of those kind of are the policy reasons that we have a statute of repose in Colorado that would cut off the timing. Go ahead.
Hey, Kate. So you had mentioned, should be unable to file a claim after the statute of repose. Have you been seeing more of an uptick lately over the last, 2-3 years in claims trying to be filed after the statute of repose? Because I know we have on our side, 10 years later or whatever, these construction defect claims still trying to come in.
Yep. And that's a really good question. I think it's interesting when the economy starts to soften a little bit, we see more people trying to bring in really old claims. And I think it's because they're trying to hit the insurance piece of the world. I said should be because there's also another wrinkle that happens here. You see that in that third bullet point is said only applies to direct claims by the owner against the construction professional, not contribution claims by a general contractor against a subcontractor. So this is a convoluted example of when you can be a subcontractor having a claim filed against you more than 8 years later. It's because a contribution claim under our statutes, you have 90 days as the statute of limitations to file the contribution claim. So what the contribution claim is, the general contractor says, I got sued because of your work, subcontractor, so you have to contribute to this entire situation. Well, there are circumstances in which the claim against the general contractor might be timely, like they got CO on the project within the 6-year statute of repose. But it turns out that maybe you're the dirt work contractor. And so you actually did your work 10 years ago, and this was a multi-building project, whatever. CO doesn't close, turnover to an HOA doesn't happen. There are instances where the claim against the general contractor can be timely, but the claim against you as a subcontractor would be barred because it's too long. But the contribution statute sort of allows the general contractor to revive the claim against the subcontractor. And that's the other place where it can be pretty sticky.
Good deal. Thank you.
Thank you. Homeowner Protection Act. So this is it's exactly what it sounds like. This is the protection act that is specific to residential property. And so the idea behind the Homeowner Protection Act is that it is trying to protect homeowners that own their own homes, that own residential property. And what it says is that it's void against public policy to waive or limit any homeowner's legal rights, remedies, or damages related to construction defect claims or Consumer Protection Act claims. And so what this is really getting at is if you want to go buy a house from Lennar can't put in its sale agreement to you, and by the way, our total liability that we'll ever owe to you is $100,000 when you're buying a $700,000 house. And if you're in an instance with construction defect where, say, there's foundation movement happening, you could be in a situation, and I literally have a couple of these cases right now, where the cost of the damages to repair the foundation movement actually exceeds the fair market value of the house. So it's like $900,000 to fix everything, and the house is only worth $650,000. So the Homeowner Protection Act is here to say you can't take away any rights and remedies that I otherwise have under the Construction Defect Action Reform Act if you're a homeowner or a residential property owner. And so the reason that I keep saying this residential property owner piece is that there is case law in Colorado that determines that residential property for purposes of the Homeowner Protection Act is actually any property where somebody is residing. And so it's been applied to senior assisted living facilities, which in most of our minds would be more like a commercial project. You're going to be contracting with the owner of the facility, who is then going to be, they don't even lease those rooms out, right? There's some kind of contract where you've got assisted living people living there, but it's not even like a rent, really. However, because they're living there, the Supreme Court has determined that makes it residential property. So if you're a subcontractor who thinks they're contracting in a commercial world on an apartment building, on a senior assisted facility, you want to keep in mind that if you try to protect yourself with a limitation on damages there to say, hey, the most you can ever sue me for is $100,000, $10,000, or the time under which you have to sue me is only going to be a 1-year statute of limitations. All of that's going to be declared void under this Homeowner Protection Act. And so that's an important piece of law that I wanted to make sure everybody that we're chatting with today was aware of. All right, anti-indemnity statute. So this one is a piece of law that relates to our subcontractors. This is going to be important for all the subcontractors to be aware of. It says, I mean, obviously you can read it, but any provision in a construction agreement that requires a person to indemnify, insure, or defend in a litigation another person against liability basically caused by the negligence or fault of the indemnity is void. So what this is general contractor cannot require subcontractor to defend and indemnify general contractor for general contractor's negligence or fault. We used to see, before the enactment of the anti-indemnity statute, we used to see some really broad form indemnity provisions in Colorado where the general contractor would say, look, if I get sued for anything, regardless of whether or not I'm partially at fault, subcontractor is going to be responsible to defend and indemnify me for it. And you need to get a policy of insurance to cover all of that. Now that is void under the statute in Colorado. Most of the Colorado kind of contractors that we deal with are pretty aware of the anti-indemnity statute. What you see more with this is when we see new contractors coming in from out of state who are trying to use kind of their existing form agreements. So like Texas is a big one for broad form indemnity. I'm trying to remember some of the other states where broad form indemnity is both still legal and they're pushing it in their contract. When they come into Colorado here, those provisions are going to be void. I prefer to go ahead and just negotiate out broad form indemnity in a contract up front and say to the other party, like, hey, this isn't, valid under Colorado law. You can also kind of rest on the assumption that you'll be able to void that clause out later in time if they're trying to enforce it. But if you're trying to void a clause later in time, it means that now you've got attorneys involved and you're paying attorneys fees. So if you can just negotiate it out of the contract up front, that's kind of the preferable approach. Colorado Trust Fund Act. This act is one that is both like a sword and a shield for you, depending on where you are in the food chain of this contract. So if you are a subcontractor to a general contractor, this is great for you because it says the general contractor is obligated to hold in trust any funds that they receive from the owner to pay you, the sub-tiers and the suppliers. And if they fail to do that, if say they pull that money out and pay it over on another project and leave their subcontractors bare on this project, then they're going to be exposed to triple damages plus attorney's fees and costs. And so the treble damages, if they owed you, it's what it sounds like, right? If it's a $100,000 project, they paid you 20, they owed you 80, that 80 mysteriously disappeared after they got paid by the ownership on that project. Now we've got a claim for, like I can do math, 240,000 in district court, right? To say, look, they basically misappropriated the funds. It's theft. We've got the treble damages, plus we want our attorney's fees and costs for it, which is great if we happen to have signed a contract that wasn't going to give us attorney's fees and costs if we had just a straight breach of contract claim for non-payment. So that's where it's a great sword for a subcontractor. That sword can be turned against you if you yourself have sub-tiers. So if you've got suppliers that you owe money to on the project, if you've got subcontractors that you owe money to on the project, the statute is pretty specific that you've got the obligation to pay them first when you get paid by the general contractor. So you can't be paying your own overhead and profit to yourself and not paying your subcontractors and suppliers. And you can't be taking that money and paying it off, other sub-tiers on other projects. It's got to be, here's the money I got paid for this project. Here's the money I turned over to my sub-tiers on this project. So it's creating an affirmative responsibility on you when you're living in that role. Oh, great question. Thank you. So the question is, does holding in trust require a GC to have a separate trust account to hold funds? No. They can keep the funds wherever. All of the funds can come into a general operating account and get paid out of the operating account. So it does get a little bit messy if we're trying to argue that there's a misappropriation, but the statute does not require that there be a separate, like, identified trust account or a separate account that is only related to that project. What they do have to do is keep the accounting in the books to show when the money comes in and where the money goes. All right, moving on to the law of contract formation. So this is just sort of the basics of how contracts are formed. There's an offer, acceptance, and consideration. And this is going to be something for you to remember when you're in the early contracting stages of a contract. So if you move us forward, yeah, so the battle of the forms is what we're going to be thinking about when we say, what's the offer and how is it accepted? So what is the offer in terms of what are the terms of the contract going to be? So if you send a bid proposal over and it's got some terms and conditions attached to it, and whoever you send it to signs off on it, that's the acceptance, and boom, you're done. You've got the offer, the acceptance, and now you have a form contract. But what happens instead if you send your bid over, they send you over a massive master subcontract agreement that's 82 pages long, that you don't sign or do anything about, but then they say, okay, go do work on the project next week, and then they pay you for it. So now we're in a sequence of events where you send your bid proposal, it's got your terms and conditions in it. They send you back a master subcontract agreement with their terms and conditions, one of which will say, these terms and conditions control, and any terms and conditions that you put in your bid are void. And now, even though you never countersign it, you go out and you do the work on the project. So the law is going to look at that and say, well, it looks like you agreed to their terms and conditions. You accepted their terms and conditions by ratifying them by doing the work on the project. So that's what the battle of the forms kind of says is last shot rule, so the last submitted set of terms and conditions, right, that it looks like somebody then acted on in reliance on the terms and conditions by going out and doing the work and paying is potentially going to be the one that is going to be the terms and conditions that the court says, like, this is what's going to apply to the between the parties. So they don't always use the last shot rule, but it's one that you should be aware of. If you've kind of are ignoring their master agreement and then you go do the work, you're probably accepting it. So it's most useful to try to get some revisions in there and say very clearly, here are the terms and conditions under which we're going to be doing our work. Now I'm ready for you. Thanks, Dustin. Okay, this is pretty basic. A lot of you on the call will already know about this, but the scope of work is going to be identifying what you are specifically supposed to be doing on this project, that you want to have anything in there that is specific to what you are agreeing that you're going to do. You want to be looking through this in terms of if you send the bid proposal, you get some sort of contract proposal back, what is the scope of work that they're attaching to that contract? Is it going to be your full bid proposal, including your inclusions and your exclusions? Or does it say something else? Like, does it refer to a spec manual that you have never seen on this project? Does it refer to architectural drawings and details that you haven't seen? So you want to make sure that when you're in this contracting environment, you're getting as clean as you can on both your scope of work inclusions and your exclusions. What's our next slide say? It says inclusions and exclusions. So exclusions are very useful. And actually, who do we have in our webinar here today? If you guys will drop in the Q&A a little bit of information about yourselves, I'm just curious to know about what type of work you do or what kind of companies you run or are involved in. That'll help me tighten up a little bit some of my examples as I'm moving forward. But say if you're a roofer and you know that there is going to be a fair amount of sheet metal flashing or sheet metal work, or maybe there's a whole separate section on like a sheet metal facade that you want to make sure that you're excluding certain portions of that because they weren't included in your bid. And you know that historically people will get confused about what portion of the flashing may be yours or not your responsibility. So get your exclusions incorporated into your contract too. Don't assume that just don't assume. Just don't assume. Get it in writing so that you don't get hooked into a different section of specifications. Incorporated contract documents. I touched on this a little bit when I said don't sign something that has your inclusions or your scope of work, having you perform work per something like a spec manual, something like a set of plans and specifications that you haven't seen before. They're going to often be incorporating documents that are part of the prime agreement into your subcontract agreement. So it could say that you're responsible for the prime contract, but you want to get a copy of the prime contract because the prime contract will probably also include or have references to a whole host of additional pieces of project documents and information, spec manual, plans and specifications, sometimes soils reports, sometimes you're going to have QA/QC standards in there. So you always want to make sure that you're getting a copy of everything that's incorporated by reference into your document. Because it's also going to have terms and conditions as well that may be impacting you in the way you're doing your work. Insurance requirements. Hit it.
Yeah, I'll take over this part, Kate. Yeah, appreciate it. So I spend a lot of time with my clients spinning through contracts. So it's part of the reason that I wanted to put on this webinar with Kate is a lot of times we see our contractors come to us with the contracts after they've already won the job. And at that point, sometimes tough conversations are needed to be had when it comes to, some of the forms that are needed. Some of the insurance, the lines of insurance that need to be included, and sometimes they don't have those coverages. So anyways, it's best, I want to preface, it's best to start off before you bid a project to send that contract over to your insurance agent, if that's not already us, over to your insurance agent to have them do a deep dive on it to make sure that your insurance portfolio already lines up with what that contract is requiring, or what the cost is to get you into compliance with that contract. So that way, you know, going in, hey, what does my bid need to be to offset the increase of the insurance cost? So as we're jumping in here, when I review contracts, this is almost every time these are the lines of coverage that are going to be included. Sometimes you can negotiate out, for instance, like the workers' comp coverage. If you're a one-man independent contractor, you can usually negotiate that requirement out, but these are going to be the most typical lines of insurance that are going to be required. So you got your general liability, your workers' compensation, auto, property damage, professional liability, which is your errors and emissions. Typically, there's a pollution requirement that's tied into that as well. Really big if you're, doing any trenching, digging underground, anything like that, that's going to be a big requirement. And then your excess umbrella liability, and then builder's risk if you are doing any sort of new builds or additions. So confirmation of coverage, as I was just mentioning, as you're bidding work, make sure you're having that conversation with your insurance agent to make sure the policy is covering you. A lot of times I have conversations with my clients on, they're not doing any new residential or multifamily condo apartments, but then all of a sudden a job pops up and they can't turn it down, right? A lot of revenue sitting out there for them. So they go ahead and sign off on the contract to win the job. They come to us and find out, hey, based on your application or based on prior conversations, you weren't doing any of this work. So the policy that you have in place excludes any new residential or multifamily work. Those are the most common ones that we're seeing because it is, it's a huge liability when it comes to class action with those tract homes, multifamily condo apartments.
The other one I see is square footage on residential. So sometimes you can think like, yeah, I'm insured to do new residential, but you don't realize that you're not actually insured to do this massive custom home project that's 20,000 square feet because your policy has like a 5,000 square foot limitation on it. So now you've got no coverage for the project.
Yeah, no, thanks, Kate. And I actually just saw another one the other day too that it's a height requirement. So on the multifamily,
Not
like
over.
the wording says over 4 stories, but it talks about from the point of, the bottom level all the way up to the top story, which also includes, and it says in the form, also includes any top decks. So a lot of these row homes that are being built right now include these top
That
decks.
have a rooftop deck that's
Yeah,
the fifth story. Yeah.
yeah. And so at the end of the day, it depends on, okay, where does measurement start? Does it start, are we grading down? So there's so much gray area in some of these insurance forms. It's important to make sure that you understand what you have. Obviously, it's not your job to fully understand that, but have that conversation with your insurance agent before signing those contracts. Because at the end of the day, you would hate to find out at claim time that there's no coverage for that work that you're doing.
Well, and don't skip out on your renewal meetings with your insurance
Absolutely.
agents either. Like actually sit down and have them remind you about what your insurance says, because it's entirely possible that last year something made sense and this year it won't make sense.
Great point, Kate. Yep, absolutely. So included, so we have the lines of coverage, general liability, workers' comp, but the other thing that is included in these contracts are additional insured wording, waiver, subrogation, primary non-contributory, which we'll jump into in a minute. But the big one is the additional insured. So, quickly, let's explain what an endorsement is. Obviously, an insurance endorsement is an amendment or addition to the existing policy, and it changes the terms or the scope from the original policy. So whatever we renewed it at, or wrote it at, this would basically change the current coverage, limits, wording, forms that are included in there. Okay, so that's what insurance endorsement means. The big one that we see on almost every contract anymore is additional insured. Now, there's a lot of different additional insured forms out there. When we're talking in the construction industry, the big one is CG 2010 and CG 2037, which is your products and completed ops and ongoing operations additional insured forms.
And when you
Um,
say CG, we're referencing commercial general liability
Commercial
policies.
general liability. Yes, thank you, Kate. I get into my geeky insurance lingo, so appreciate you stopping me on that. But yes, so those are the two big ones. And at the end of the day, those are the ones that are protecting the general contractor from, or protecting, yeah, the general contractor from being sued and basically your policy covering that job. Okay, so that's what these additional insureds, they want to be listed on your policy as additional insured because it's protecting them. This is what you're doing by signing these contracts is your work is going to be covering the general contractor or whoever the contract is with for your work. And at the end of the day, like I said, we're seeing both those completed operations and the ongoing operations, additional insured forms being required.
So an illustration of how those two would work is if you're if you're a subcontractor who has the general contractor listed as an additional insured for ongoing operations, and you drop a pallet of roof shingles onto a bystander, and the general contractor gets sued for that, that's ongoing operations while you're on the project and somebody gets injured. So now the insurance policy is going to defend you plus the general contractor for those damages. Completed ops is the kind of stuff I was talking about with the statute of repose. Like you're off the job, it's been done for a long time. Now there's an allegation of some kind of defect in your work that's arisen. That's going to be the completed operations side.
Absolutely. And now there is a charge typically more times than not for those forms. So, it can range anywhere from probably 50 to $100 per an additional insured. So as you're signing these contracts or as you're having your review with your agent, with your insurance agent, make sure you have the true number of AIs that you're requesting additional insureds that you have throughout the year, because once you get up to typically the number is 10 is the break even point. If you have 10 or more, just get a blanket additional insured form on there because you're paying one time for that form, then you're not having to pay throughout the year. So get that blanket on there. It's the easiest way to do it.
The other really nice thing from a litigation perspective is that the blanket option says anybody that you are contractually obligated to add as an additional insured is going to be determined to be an additional insured under this policy. So the blanket option is great because yes, it's still best practice for you to get the certificate showing that you added them as an AI. But if for whatever reason you forget to do it, now after the fact, we can still argue that they were automatically treated as an additional insured under that blanket option. So it's a really nice piece of protection to have.
Absolutely. And one thing I did forget to mention as well, while this webinar is designed for subcontractors, and it's explaining kind of what you're getting yourself into when you're signing these contracts. These line items that I'm kind of talking about here are best practice when you're hiring subcontractors too.
That's a good
So
point.
if you have any subs that are working underneath you and working on behalf of you, make sure that you're talking to your attorney, getting your subcontractor agreement in place so that way it has all this verbiage too, because you want to protect yourself as much as the GC's protecting themselves. So yeah, make sure you have all this verbiage as well. So here's an example of an additional insured endorsement clause. So you'll see here, it just basically goes through, explains the subcontractor shall add blank as additional insured to the CGL, which is your general liability policy, by having the insurance carrier issue an additional insured endorsement. And there's that CG 2010 that I was talking about. And so anyways, it goes on, you can see line item I and line item II that, provide coverage for both premises and ongoing operations and products and completed operations. So that's, I was mentioning that you typically see both of those anymore. And then provide coverage to the full extent of the actual limits of subcontractors coverage, even if such actual limits exceed the minimum limits required by this agreement. So anyway, so this is a typical additional insured. There's some OSIP, which is your owner's subcontractors protective liability policies, and then there's wording for the wrap below that. Essentially, if you haven't ever worked in an OSIP or a wrap, essentially that's a general contractor that has purchased a policy to cover the whole job. Any sub that's doing work on behalf of that general contractor under that wrap or OSIP is covered under that. So your policy more than likely excludes work done under a wrap or OSIP because it's going to be covered under that policy. So just one thing to keep in mind as you're keeping, your books up to date, make sure you're subtracting that revenue, those receipts, the costs, the revenue, payroll from your other jobs because you don't want to have to pay twice for them.
So with the OSIP, it's usually funded by saying subcontractor is going to contribute to the premium on the OSIP, yeah, and we're going to withhold X percentage off of your payments to help pay for the OSIP. So since your general liability policy is always going to exclude a wrap policy, and you're separately paying for that wrap policy, it's exactly what Dustin is saying. You want to be tracking how much you're paying separately for that wrap, and then you're not reporting to your GL policy what you're making on, a wrap insured project because it's not part of what you actually asked them to insure or did insure. And that's also why we have that last sentence there struck under section H, because it's bullshit. You can't, if there's any doubt about whether you're insured for coverage under the wrap, you maintain your own insurance coverages. Well, okay, but that's the whole point. Your general liability policy itself is going to automatically exclude you from coverage for a wrap. And so saying, hey, I'm going to be paying twice when the coverage you're telling me to pay is automatically going to be void with this wrap. That's why we strike language like that.
Yep, absolutely. So before I mentioned primary and contributory and waiver of subrogation. So again, this I'll explain kind of what these two endorsements do. Once again, talking to if you're hiring subs, make sure this language is in your contracts as well. So let's start out with the primary non-contributory. So what this does is it basically is saying that your policy as the subcontractor while doing work for Mr. GC, your policy is going to be primary and their policy is not going to be contributing towards the claim at all. So it's one more layer of protection that basically your policy is the only one to be responding. And if you're the one that's negligent, you're the one that's at fault, it's, the GC is not going to be, their policy is not going to be responding. And then one final layer of protection is the waiver of subrogation, which basically says, hey, now that my policy as a subcontractor has paid out on the claim, I am waiving my rights to now subrogate against the general contractor's policy to try and recoup some of those monies that were paid out in that claim. So those are, again, are two strong ways to protect yourself when you're hiring subs, but also just know what you're doing when you're signing off on a contract. When it has this language, now you've got additional insured. So the GC is now covered under your policy as an insured, as an additional insured, but you're also waiving the right to subrogate against their policy and also waiving the right to have that policy not contribute any funds towards the claim. Again, this is only if you're at fault.
All right, so that dovetails into the next slide, talking about defense and indemnity. So this section of the presentation gets into more specific contract clauses themselves that you might be looking at. But the reason we want to talk about defense and indemnity in the context of that additional insured endorsement is they are sort of the same and they are sort of not. So a defense and indemnity contract clause is the actual contract clause where you say subcontractor is going to defend, indemnify, and hold harmless the general contractor for any types of damages that our work may cause on the project, is the general component of it. And you may think, okay, well, if I say that I'm going to defend and indemnify them, and then I go ahead and I get the additional insured endorsement, so now my insurance is going to be responsible for stepping up for them as an additional insured, and it's the insurance that's actually going to pay the costs to defend and indemnify the general contractor. So those things do work hand in hand if you've got the additional insured endorsement in there. Now, if there's a lawsuit that involves both you and the general contractor, your insurance should be stepping in and defending you for your work and also defending the general contractor for the portions of the work that are alleged or the claims that are allegedly arising from your work. Like that's how it's supposed to work. But it's really important for you to understand that there's still two separate obligations. So the additional insured obligation is what's happening on the insurance carrier side in terms of how they look at coverage and their obligation under the policy to step up and pay an attorney to defend. But that doesn't fully take away the separate clause, which is I, subcontractor, contractually agree that I'm going to defend and indemnify for the damages that are caused by my work. Meaning that if, for whatever reason, the insurance policy doesn't step up and do what it's supposed to do, there's still a fully enforceable separate agreement that flows directly to you as the subcontractor. So it's important to recognize what you're signing up for when you say you're going to defend and indemnify. There is a difference between defense and indemnity. Go back still, sorry. There's a difference between defense and indemnity. The duty to defend, that's that fourth bullet point down there. This is saying, I am going to defend you. I'm going to pay your attorney's fees and costs to defend you against allegations of defects in my work as soon as those allegations are made. So it arises as of the date of the filing of the complaint. It exists wholly independently of whether or not you actually did something wrong. It really is simply, as long as there is an allegation of a deficiency of work on your part, that triggers day one, your obligation to be paying that general contractor's attorney's fees and costs. So defense and defend is a separate duty entirely, and it stands apart from whether or not at the end of the day, somebody determines that you did something wrong. Indemnity is the piece of the world that talks about whether you did something wrong. So indemnity is the allegation that we put the windows in, we reversed lapped some of the flashing on the windows. Now there's water coming into the building. It's going to cost $50,000 to fix the windows. Well, if it costs the general contractor $250,000 to defend themselves up through the point in time that there's a verdict saying it's a $50,000 problem, your net responsibility under defend and indemnify is $300,000. So you can see where there's a big difference in sometimes the cost of the duty to defend versus the indemnity in a case. And that's, go ahead. I don't remember what the next slide is now. Right, indemnity clauses. So that's part of why I wanted to talk about that anti-indemnity statute at the beginning of our presentation, is when you're looking at defense and indemnity clauses, here's what we did to amend. We took out the defense obligation. So that's the first thing we struck. We took out the word defend, protect, and hold harmless. Because we're trying to get ourselves absolved of that defense piece of the world where we're paying somebody else's attorney's fees, even if we didn't do something wrong. We can always say, well, gee, I've already agreed to add you as an additional insured under my policy. So my policy is going to pay you, or it's going to pay to defend you. And that is a standalone obligation that has nothing to do with my defense and indemnity clause. So I don't need defense in here. That could be a talking point for why you take it out when you're talking to a general contractor. And then the other thing that we did was going back to that anti-indemnity statute saying it's void for me to agree to indemnify you for something that you did wrong. We're just cleaning up this language arising from or in connection with our work to say only to the extent that the claims are found to have been caused by our work. So we're really leaning into the anti-indemnity statute language to say we don't have an obligation to defend you or to indemnify you rather unless we actually cause the damage that's at issue. And then I think I have another amended clause after that. Nope, I think I switched us right into liquidated damages. I'm just gonna talk briefly about the liquidated damages because there's still a couple other topics that I wanted to get into, and we're gonna run pretty short on time here. So liquidated damages are, you've probably seen them in contracts before, usually for construction. They relate to damages that you're going to have to pay back to the owner if you don't finish the project by a certain point in time. But the whole point of liquidated damages is that it's supposed to be this amount of money that is supposed to be the best estimate of actual damages that can be incurred. A really good example for this one is hotels will often have liquidated damages asserted past a certain date and time for completion because they need to get open and operating. And especially if it's a hotel that's going to do big holiday business, they want to be open by October. They don't want to be opening January 1 because they've missed the entire holiday season. And so the reason they'll have liquidated damages, like a daily provision for damages that are assessed if they're not done and open, is because they're losing real money and it's suffering real damages if they're not open. So liquidated damages, what you want to absolutely be sure of is if you're signing a subcontract agreement, you need to know if there's liquidated damages in the prime agreement and if you're potentially going to be exposed to responsibility for those. Let's go ahead and skip though to the other concept, which is, it should be on like slide 27, pay if paid. So this is the other one that I want to make sure that everybody's aware of when we're talking about subcontractor kind of contracting environment. Pay if paid clause says, look, general contractor's obligation to pay the subcontractor only arises if they have been paid by the owner. So it is shifting the obligation for payment to the subcontractor. It's jumping the general contractor and it's over to the owner. And the GC says, look, I never have to pay you if I myself don't get paid. It means now you're relying on the credit of the owner. Pay if paid is a specific condition precedent to their obligation to pay you on the project. So you want to be very aware of whether or not you're dealing in a pay if paid or a pay when paid environment with a general contractor. Pay when paid is something that says something like, our payments to you are going to be due 7 days after payment by the owner. And that's all it says. And so maybe it doesn't say, and if the owner doesn't pay, then you don't get paid. If it only says 7 days and the general contractor is arguing, well, I never got paid, so that 7 day trigger didn't happen. The law in Colorado is still the general contractor has an obligation to pay. The general contractor still has an obligation to pay you within a reasonable amount of time. They haven't fully shifted the entire obligation of the contract over. So pay if paid has to be accompanied by pretty specific language that says like, look, this is a condition precedent, the payment by the ownership. You are accepting the owner's like credit and payment with the general contractor has no responsibility. Those are the kind of things that are going to flag pay if paid versus pay when paid to you. What do I have on the next slide here? Here we go. Sample pay if paid. This is where you've got prime contractor and subcontractor intent that sub is only to be paid if the owner first pays. So you're really seeing a risk transfer that's coming through here. And then let's switch to the next slide. We'll hit lien waiver modifications pretty quickly. So this is another consideration that you have when you're reading a contract that a general contractor hands to you as a subcontractor. So this is where subcontractor is saying, I am going to agree that no liens will be placed on this project, and I'm basically holding the contractor harmless from any liens from my sub tiers. Well, you don't want to just give this blanket promise because if this blanket promise, the way it's written, is saying, I am going to be paying upfront for all of my subcontractors and suppliers, and I will be financially responsible for it. You can see how if you have also signed a contract that says pay if paid, now you're requiring yourself to front all of the money to fund this project, and general contractor has no obligation to pay you. So you're fronting all of this money for the owner. And if the owner never pays the general contractor, you're never getting paid, but you've sure guaranteed that you're going to make sure that nobody liens the project. So now you've got the situation where the owner has all of this benefit to themselves if they don't ever pay, because you said right here, you agree that you're not going to allow anybody to lien the project. So the way we modify this is to say, look, we're only going to agree that we're going to hold you harmless and not lien the project to the extent that you have actually paid us for the materials and services that are the basis of the lien itself. So that's another one that I always like to make sure we do a good job buttoning up in our contracts to say, if I'm going to agree to hold anything harmless on this project against liens, it's only going to be the extent to which I actually get paid and me and my subcontractors actually get paid. Retainage. So if you flip to the next slide, that references where we're at. We're now supposed to be down to 5% retainage for most projects in Colorado. So that's another one to make sure that you are amending that in your contracts. And then right to stop work is the next slide. And this is pointing out to you, you need to have a provision in your contract, if at all possible, that allows you to stop work if you're not being paid. And especially if you're working in the pay if paid environment. And then last one, forum selection and venue. Make sure that you're in Colorado, that you are in the location of the project, that you're going to be hailed into court in Colorado, that you're not signing a contract that says that disputes are going to be resolved in AAA arbitration in South Dakota. Like, you want to make sure that you are not setting yourself up to have to go somewhere hugely inconvenient if you have to pursue any claims on the project. And then finally, attorney's fees. What you're looking for is the opportunity to recover your own attorney's fees and costs if you aren't paid on the project. So unilateral is the one where the contractor is saying, oh, I get to get my fees and costs. If the contractor is saying that they're going to recover their reasonable fees and costs, you want to make sure that it switches to being bilateral. Look, if there's a dispute, whoever is the prevailing party gets their fees and costs. Under Colorado law, attorney's fees are only recoverable if the contract or statute provides the award of attorney's fees. So that's why I was talking about contractor trust fund at the beginning of our session. Contractor Trust Fund Act allows you to get attorney's fees. Mechanics lien statute does not allow you to get attorney's fees and costs. So even if you have a valid mechanics lien, you are not going to get an award of fees and costs for filing that lien foreclosure action. And so if it's only a $15,000 lien, I can pretty much guarantee you're going to spend more than that in attorney's fees and costs by the time we do the foreclosure action. So all of this comes back to get your right to recover your attorney's fees for non-payment written into that contract, because otherwise you can just find yourself economically upside down on the proposition. All right, and that brings us to 11 a.m. And any questions that anybody might have for us?
And while you're putting them in, we have everybody muted, so throw the questions in the Q&A. Sorry, everybody. But while you're typing those in, Kate and I are going to throw our LinkedIn links into the chat area. Feel free to connect with us, and then we can answer any questions offline too, if need be. But yeah, we'll give everybody. I know, looked like Brian was raising his hand, so.
I think I'm doing this right. Jerica, you might have to chat that. Are we putting it in chat or in Q&A?
Yeah, throw it in chat.
Okay. That's our, I think that's our LinkedIn company that's galvanized. Jerica, I know you're on. Make sure we're doing it right. And then,
Okay, I will do that.
thank you.
Mhm.
And then I think this is me on LinkedIn.
Perfect.
All right.
Okay, let me go back.
And it looks like we don't have any more questions in the Q&A.
We got, oh, yes, thank you, Laura, for mentioning that. So yes, we did record it. Kate, do you want to share the slides in the?
Yes, we will go ahead and we can PDF those slides over. I think that they all have the language on them that's basically like, I'm not your attorney unless you hire me, so not your attorney unless you hire me. The slides are
Perfect.
all for educational content only.
Good deal.
But happy to share them.
So yeah, we'll send out the recording, we'll send out the slides, and again, we'll send out a survey as well. And then real quick before we go, Brian's got a question. When can we file a lien if we are not ever paid, or when we are not ever paid, when paid, or pay if paid? should we file it when we start the work or then remove it when we are paid?
So short answer is you can't file it when you start. You have to file it when you complete it if you haven't been paid. So you can't just like automatically, you can only lien for work that you've actually completed and the value of what you actually completed. Yes, you can lien regardless of whether your contract says pay if paid or pay when paid, because mechanics lien statute sits outside of the contract and it basically says if you are providing a benefit or value to the property, then you can lien for the value of what you benefited the property that you didn't get paid. And so what you want to be careful of is that you not lien for like retainage if it's not yet owed on the project, because you do have that piece of the world of like, if they don't have an obligation to pay you the retainage yet, the idea is that you lien for the amount that you billed for first, and then we can do a notice to extend the lien and we can lien for the retainage when it like later in time becomes due. You don't want to lien for like unpaid interest unless the contract specifically allows you to collect interest. But you can, sorry, I'm wandering a little bit. The mechanics lien, unless you, that we talked about that contract provision on mechanics lien waiver. Unless you said, look, I promise that I'm going to hold you harmless and never allow the project to be liened in the contract, unless you gave up your mechanics lien right itself in the contract, you can always separately file a mechanics lien because the mechanics lien statute operates independently. It just gives you the statutory right to create the property interest since you benefited the property to a certain amount. Did that answer your question, Brian?
Perfect.
Well,
And then one more if you have time, Kate. This comes from Stacy in our office. So how much time is needed for contract review from your attorney to revise contracts before signing?
That's a little bit of an it depends, because it depends on the length of the contract. There's a lot of different contracts come from a lot of different sources. So there's the American Institute of Architects, the AIA series of contracts. So if somebody just sends me a copy of one of those form contract agreements, even if it's 30 pages long, the way they mark them up is you can just run through it and see where there's been a revision to it. So it doesn't take me that long to like look at it and understand it because I know those forms. There's also the consensus docs, which come through AGC that's sponsored by them, and those don't take as long. But then if you have something like the Swinnerton, the D.R. Horton, the whoever master subcontract agreement, they had an attorney write that themselves, and it's 150 pages, and it's going to take me 2 to 3 hours to like get through it, and then probably an hour to talk to you about, okay, here's how bad it actually is. Are you going to sign it, and where are we going to pick our battles on your approach to it? And then there's kind of everything in between too. Sometimes it's just a question of somebody's got a short little agreement, 10 pages or less, and it doesn't take me more than a half hour to read through it and be like, hey, here are the 3 pain points, and this is what I recommend. So it kind of different contracts take different amounts of time to work on. And then the other thing our firm does a lot is we do education. We can do a separate education session for you for your company so that I'm training your contracts people to understand what they're looking at and how they should be changing themselves. So if I teach you to fish, you can be taking the first crack at your contracts, understanding what you're seeing and understanding when you might want to call an attorney in to help you with a higher level of review.
That's great, Kate. All right. Well, perfect. We've kept everybody, it looks like 6 minutes longer than we said. So I apologize. I know you guys are all busy. But thank you for attending. Again, keep an eye out for that email with the slide in the recording. Pass it around to anybody that you think might want to watch us, might be interested. And then, yeah, if you don't mind taking that quick survey in that email as well, that would be greatly appreciated as well. Other than that, everybody have a great rest of the week.
Thanks, everybody. Thanks for coming today. Take care.
Thank you.